Hi, I'm Paul Anticook, and we are doing another one of these brief introductions, 5 to 15 minutes, about things that are connected to Alaska Native cultures, communities, people, and Native American cultures, people, and communities. This one is pretty difficult to jump in. We'll see how far we get in 15 minutes. What we're going to be looking at is federal Indian law within the law of nations. The strange part about it is that we do have this. We don't have federal Korean law. We don't have federal African American or Black law in particular. It's not a body of law, but we do have one for Indian tribes. Federal Indian law is the law that relates primarily to the tribal status of Native Americans. And this impacts Alaska Natives as well as other groups. We have over 200 tribes recognized by the federal government in the state of Alaska. So we need to take a look at what this is all about. And it's very important because it's primarily about taking land from Indian tribes, sometimes without their consent, and often in ways that would violate the terms of a contract. If you are forced to sign a contract at gunpoint, you have no free will. And if you can show that that was the case, then that contract can be voided. One of the most important things that distinguishes federal Indian law is, particularly when it comes to land, that lack of free will is not considered by the courts to be reason to void that contract, which are called treaties between the federal government and with Indian tribes. So how did we get there and why? How do we have this thing called federal Indian law in the first place? Well, it has to do with the law of nations, but it's not all nations. This was done particularly by the western side of the Christian church. The churches are divided up between the Greek section to the east, Greek speaking and writing, and the Latin church, which would be the western part of it. That western part had just pushed the Islamic expansion out of Spain in 1492, which happens to be the same year that Columbus is doing his thing. When Columbus does his thing and he shows up in a world that Europeans didn't know about, which the Europeans call discovery, the problem was there's now going to be a land rush among these Western Latin-based Christian nations. And there was a very real danger that they would come into open conflict with one another over these lands. So the Pope, the religious leader of this western part of the Christian church, his office steps in. And what they try to do is become a referee on this whole section of things about the rules in which Christian nations can take land in other places without coming into conflict with one another. The first rule of the road was that the papal office divided up the New World by just doing a vertical line from one pole to the other, and on the western side of that line, all that land would become a part of Spain. It would become the rights of Spanish occupation. On the left side, or the eastern side, it would become a part of Portugal. Portugal would have it. So there would only be two nations that controlled all the powers, the rights of the New World under this initial decision. It's amazing. The Portugal was able to negotiate, however, that there was one river and a river basin that supported that river. They said, well, this vertical line thing, we'll go along with it, but we just want this one exemption that wherever this river is fed, all that land would be one place. It would belong all to Portugal. Spain didn't care because, I mean, who cares about one river? The trick on it was that river was the Amazon. And that is why today the largest Portuguese-speaking nation on the planet is Brazil. Now, that falls apart as the rules of the road for discovery. And what we end up with is a new set of rules. And the new set of rules evolves over time. But essentially, what it is called are the laws of discovery. These are laws created in the interests of these Christian nations, Western European nations, so that they don't come into conflict with one another, weaken themselves, and have a resurgence of Islam overtaking these Christian nations. So it's a rule of the road to try to avoid conflict. What does this do if you are native peoples? How do you deal with it? Well, a part of it is you have to understand what the Europeans are saying are the rules of the road, how those impact ownership. And what happened is that you had to show that you had actually discovered the location that you were claiming. And that took a variety of forms. One is you could take unique flora and fauna, plants and animals, and collect them. And you could show that as practical evidence that, in fact, you'd been in this unique place, this new place unknown to Europe. And that's why we get this collection of plants and animals that becomes so complicated that somebody named Linnaeus said, we've got to organize our understanding of all these plants and animals, and he comes up with the scientific system of taxonomies. The other way that you could do it, establish rights of discovery, is that you could do it by leaving evidence that you were there. And that's why you get these paintings of Europeans getting off the boat and they're planting something, a symbol of the nation they represent, on this particular place of land. And that's also why they leave these medallions, these large metal pieces scattered all over the place in what they consider to be their land. They're trying to leave physical evidence of having been there. And it's also why, if they meet with native peoples in that area, they're really happy about handing out these large medallions to the whatever they think is the leadership of the tribe. And so if these medallions are worn by the Indians, then it's clearly that nation that gave those medallions to the tribal leaders. It's going to be their land. The land, though, is, under right of discovery, is you have a right to go into those lands. And those lands are taken by either a just treaty or in a just war of conquest. And there are rules about this. You can take law courses about what constitutes a just war. That's what Indians or native peoples of the New World are facing, this set of laws. And it's this set of laws that were encouraged and refined with the assistance of the Catholic Church that are these laws of discovery. And the impact of it is that law of discovery means that you have the exclusive right to establish by war or by treaty a land base in this area. You can take land for yourself. Now, morally, how do you justify taking other people's property, their lands, their very nation's homeland? Well, it's done under two principles. One is that you're bringing civilization, which is supposed to be better because it's their own, it's the Europeans. And the second, and this is really important, is that you are spreading Christianity. And that latter part of the deal is seen as the key by which you can take land in order to promote Christianity, eternal salvation for these native peoples. And if you have to protect the missionaries so that they don't get killed before they convert the native peoples, that's overhead. And you can pay yourself as a nation that overhead by taking land, by taking labor also from these people. That's federal Indian law. That becomes the foundation of what we call federal Indian law. Now, some people might wonder, well, what about the Protestants? Well, the Protestants are really forming up as a branch within the Catholic Church. They're protesting corruption within the church. That's what it meant. So it's a branch of the Catholic Church to be Protestant. And these nations that become Protestant, although they become Protestant, they still go along with the rules of the road concerning discovery. So among other nations, Britain continues to go along with these laws of discovery in shaping the occupation of the New World. When the American colonies, have a rebellion and eventually succeed in establishing their own nation, the United States, those laws are continued within the framework of the United States Constitution. And that's how we have federal Indian law within the law of nations. We'll talk about some of the consequences of this in another presentation. It's complicated on first go around. It's well worth understanding and checking out, because if you don't understand this, one, you're going to misunderstand the foundations of the laws within the United States, and two, you're going to particularly be confused about Native Americans and Alaska Native legal status within the United States. There's, in fact, an entire section of federal Indian law that you can take in law school in the same way that you can take tax law or corporate law or any other field, and it's encompassed. And here's an example of it. In fact, this is the original one. This is Federal Indian Law, the Handbook of Federal Indian Law, and the author is Felix Cohen. And this, a document that was put together by Felix Cohen, was done in 1941, 1942, in the midst of World War II. He took all of these conflicting, confusing laws that impacted Indian tribes and said, we can't understand how to deal with the consequences of these treaties unless we have a coherent understanding of what these laws are. And he created it. It's unique in my understanding of laws, bodies of laws within the that affect American justice, in that you can point to a person who organized it and made it federal Indian law, Felix Cohen.